Hi, everybody. Thank you so much for joining us today. I am Michelle Morris from Consolidated Planning Group, and we've got a fantastic webinar with attorney Bill Hayes. He's going to be walking us through the ins and outs of guardianship, alternatives to guardianship, all of that great stuff that we need to know about. Before we get started, a couple of, housekeeping items. I want you to know that we cannot hear or see the participants. So please use the chat box for any questions or comments. We do want to hear what you have to say. You just need to put it in the chat box. I've already put my contact information in there. So if you have any questions after the webinar, maybe you don't want to share it in public, or maybe we miss your question, you can feel free to reach out to me afterwards. The other thing I want to let you know is that we always record our webinars. This is live. We present live, but then we put the recording onto our YouTube channel. So if you have pre-registered, you're going to receive an email later today that has a link to the recording and all of the slides that we presented. If you happen to be watching on our YouTube channel, or maybe you're listening on our podcast and you want a copy of those slides, you can feel free to email me or call me or email the office. That address is contact@cpgcares.net, and we can get you a copy of the slides that way. So again, I am Michelle Morris from Consolidated Planning Group. We are a holistic, special needs focused financial planning firm. We are located just outside of Houston, Texas, but because of virtual meetings, we are able to work all across the United States. So anybody that you know who is in a situation where they have a loved one in their life with any kind of developmental or intellectual disability, we can help them. We truly understand the unique challenges that you face because we are also parents of individuals with needs. We've been in the business of helping families with financial planning for over 30 years. We are fully licensed. We can do investments, life insurance, planning, retirement, all of that stuff. But we do it through the lens of understanding that your individual might need your help for the rest of their life, not just your life. So we are dedicated to families in the special needs community. We are members of the Special Needs Planning Academy. We are chartered special needs consultants, um, nationally certified Social Security advisors, and almost every single client that we work with has a loved one with a disability. So we can help you think about things like lifetime care planning, protection plans for your family, transition planning and ABLE accounts, and kind of how the money needs to flow to protect your loved one's benefits. And we are dedicated to advocating for you and educating you. And, when you're with Consolidated Planning Group, we are rare because out of 263,000 plus financial advisors out there in the United States right now, fewer than 200 firms truly focus on special needs planning like we do. So that's less than a tenth of a percent of all the financial advisors who can help you and are truly experts in this area. So you're in the right spot. Just a few tips before I turn everything over to Bill to talk about guardianship. Start thinking about what is going to happen after high school and start planning now. It doesn't matter how old your loved one is, but the longer runway that you have in order to make these plans, the better your plan is going to be. And you can make small changes that are going to have a larger impact on your family. Tour opportunities. After high school, there might be a residential or a transition community for your loved one, day programs. There are educational options. There are vocational options, but some of them might have waiting lists. So you want to tour these opportunities early, see what would be a good fit for your family, and get on those waiting lists. And then finally, my last bit of advice is to think very carefully about successor caregivers. Who is going to step in to take care of your loved one when you can't do it anymore? A lot of people think, oh, well, that's easy. Little Jacob has a big sister named Sarah, and Sarah will slip in and take care of everything Jacob needs. It'll be fine. Well, right now, Sarah's all gung ho and she loves her brother and she wants to help. But when Sarah's in her 30s or 40s, it might be a different story. It might feel more like an obligation and biting off more than she can chew. And from the other perspective, little Jacob, he's had Sarah, his sister and partner in crime all these years. They're best friends. And now Sarah wants to join in, wants to step into the role of being more of a caregiver. That might feel like a little bit of an authority position, and it might cause some friction between the two siblings. So just be careful if your family is actually going to be able to stick with that promise and if that's truly the best thing for your kids. One client that we had said, the best gift that we could ever give to our neurotypical child is to make sure that our other child is taken care of, the one with the neuro diversity, that he's taken care of to make sure that she doesn't have to do that in the future. So think about that for your family. All right, Bill. William Hayes.
Okay,
It cracks me up. I'm so sorry. I've known you as Bill for all my life
that's fine.
in this role, and now I see William Hayes, the attorney and managing partner at Hayes and Wilson. So you can take over. You can click on the screen and take over control of the slides.
Okay, thank you.
And again, if you have any questions, all of you participants, please put them in the chat box. I'm going to keep an eye on that and let Bill know as those come in.
Okay, thank you. Actually, looking at this slide, I just realized I forgot to make a change. I was managing partner, but at the beginning of the year, I turned it over to one of the other partners. I think my title now is curmudgeon emeritus. So I need to update my slide. I've been doing this estate planning, special needs planning, guardianships, probates for about 34 years now. I had a former lifetime as a corporate securities attorney. You don't you don't want to grow old doing that. So I switched over in 1992 and have thoroughly enjoyed. I became board certified. Our small firm is a boutique firm that just focuses on these areas of estate planning, special needs, guardianship, and probate. Four attorneys, five paralegals, some support staff, and that's pretty much all we do. So we're somewhat unique in that regard. And Harkening back to something that Michelle said, um, I have a special needs daughter. She's now a resident in the Brookwood community in Georgetown, Texas. They took the Brookwood concept from Brookshire and they've duplicated it in Georgetown. What she's excited about is that instead of their public-facing enterprises, one of them is going to be a pet resort, and she loves working with the animals. So she's looking forward to that, which will come along in phase 3. And then my partner, Lisa Wilson, her daughter with Down syndrome was with a resident through the REACH program up in the northwest part of Harris County. We're living in one of their group homes. So we've got a vested interest in trying to understand this area of the law, and we enjoy helping others who are facing some of the same issues. So diving in, let's see if this works. I'll try this one. There
There
we
you
go.
go.
Um, when your child turns 18, theoretically they become a legal adult with full rights to make their own decisions. Uh, and Regardless of their disability or incapacity, at least we start off with the assumption that they are capable. You lose the legal right to access their medical records. You can't no longer make medical decisions for them. You can't manage their finances any longer, and the schools and doctors don't want to talk to you. That's what the law says. Now, as a practical matter, you may be one of the fortunate families that you continue going to the same doctors and third-party providers with your child as always, and they continue to involve you in the conversations. With my daughter, who was severely incapacitated due to a brain injury, we didn't have to get guardianship on her until she was 43 years old because we never needed it. All of her doctors and everyone that we dealt with got it, and they continued to work with her mother and I, and we didn't have any issues at all. It wasn't until Brookwood required guardianship that we finally engaged and did that. So the practicalities of it, if third parties and doctors will continue to work with you, yay. But if you really want the legal authority that's necessary, you may want to consider guardianship. But that's only one of the tools, and we try to use guardianship as a last resort. Let's see how I did that. Um, yeah. So is that the right?
Yeah,
Yeah, okay, there we go. So
perfect.
guardianship, it's a legal process, it's a legal relationship. The court appoints someone, the guardian, to make decisions for another person, the ward, based on the fact that that ward has either partial or total incapacity. Um, so incapacity is the magic word. An incapacitated person is either a minor or an adult, anybody over 18 in Texas, who, due to a physical or mental condition, is substantially unable to provide for their own needs, care for their own health, manage their own financial affairs. Uh, and that's not always clear as to when that line is crossed. It's actually very fuzzy sometimes. So we have to get a doctor's letter. Uh, your proposed ward has to be seen by a doctor. It can be any doctor. Um, and the letter, they have to fill out a standardized 4-page letter that is used pretty much in all of the courts in Texas, especially in Harris County. And it has to be dated within 120 days prior to when we file for the guardianship. On the first page, there's a box that we have to give the proposed ward a Miranda warning. We have to advise them that the doctor has to advise them they're being evaluated for purposes of a guardianship. And then it goes through and slices and dices their life. What do they have the capacity to do or not do? Do they have the capacity to make financial decisions, to manage money, to operate a bank account, to operate a motor vehicle, to get married, to vote, to possess a firearm? I mean, there's like 30 or 40 different things that get checked off what they have capacity to do or not do. But if we get a letter from the doctor that shows even partial incapacity, that can be a predicate for establishing a guardianship. Um, okay. There we
There you
go.
go. I got it for you.
All right. Think I'm going to have to rely on you. Mine's not.
Okay.
So there's two primary types of guardianships. There's guardian of the person. The guardian of the person decides where they live, who their doctors are, who sees them, what privileges they have, etc. Guardian of the estate is a royal pain. That person manages the ward's income and assets for the benefit of the ward, and as we'll talk about later, they have extensive reporting requirements. Basically, you have to keep receipts to the penny. You have to do your accountings to the penny, and they have auditors that audit to the penny. So it's very tedious. And the reports that we turn in on guardianship accountings, we have one paralegal that's dedicated to doing nothing but those because they're not in a format that you would ever see anywhere else. Just suffice it to say. Okay, here we go. Guardian of the person, relatively light on reporting. You just have to do one annual report of condition, location, and well-being. Has anything changed? One of the things that we're very concerned with is whether someone can improve. And so we always have to examine what other supports and services might be available in lieu of a guardianship. Do they have the capacity to execute a power of attorney? Do they have the capacity to execute a supported decision-making agreement? Or do any of these other things that would possibly obviate the need for a guardianship? And does that change over time? For instance, my daughter, after her brain injury, started off in a persistent vegetative state. They were recommending hospice care. Here we are 20 something years later, and she's back to full functioning, except for her short-term memory. But in terms of everything else, she's great. So people can improve. I had one instance recently with an adult who got into a domestic argument with his spouse. His stepson came down and beat him over the head with a baseball bat. We weren't sure that he was going to live, but he did. And his brother got total guardianship on him. 5 years later, we got the guardianship completely removed because he had regained enough capacity that he could do everything for himself. He still had some disabilities and wasn't able to go back to work. But in terms of managing his finances, hiring caregivers, keeping track of his government benefits, things like that, he was perfectly capable of those things. So we were able to completely undo the guardianship. I've had two or three other instances where we've been able to completely restore a ward to full functioning and give them back all of their legal rights and capacities. So it's something that we always monitor and keep track of. And that's part of this report that is turned in annually of what has changed and has there been any improvement and is there any way to make this guardianship less restrictive or possibly more restrictive if it was a partial to begin with. Um, Guardian of the estate, again, this involves extensive court review of all income expenditures, assets, annual accountings to the penny. Inevitably, you will have spent money off budget. When you have a guardianship and the ward has assets, you do a monthly budget. Well, what's his rent, utilities, food, stuff like that. What are we going to be spending on a routine basis for this person? And we get court authorization for that. Theoretically, we're supposed to get court authorization in advance before we do any expenditures of the ward's money. As a practical matter, you're going to be spending money from time to time on miscellaneous things, and it's not worth going to court for that small thing. So inevitably, at the end of the year, we file an application for we do the annual accounting, and we also do an application for reimbursement where you've spent some of your money on the ward that should have come out of his fund, and you've spent some of his money without court authorization, and you're having it ratified. So it gets to be the annual accounting process can be somewhat convoluted. And that's why we have a paralegal dedicated to doing nothing but that because she's an expert at this now. Um, Alternatives to guardian of the estate. Again, if there are any government benefits, we can talk about having somebody set up as the benefits payee representative. That's good for SSI, SSDI, any kind of VA benefits. We also have a new thing in the law where if a small amount of money comes into the ward's name, the guardian of the person may manage up to $20,000 without going and establishing a guardian of the estate. Now, the first party special needs trust, this is the one that you'll really want to consider using because anybody who wants to set aside money for the benefit of the individual, we can't put it directly in their name because they lack the ability to manage on their own behalf. They may be frivolous with it. They may not be able, it's just not a good idea. Excuse me, so if it's their money, we do a first party special needs trust. And if it's their money, there has to be a Medicaid payback provision. Now, a lot of these benefits, like SSI and Medicaid, the government keeps score. And when somebody passes away, they want their money back. So if it's been the ward's money put into this trust, and there's any money left when the ward passes away, there's a Medicaid payback provision. There's also a third party special needs trust. That's the one that you would create for the inheritance that you leave on behalf of the ward. The only difference is there's no Medicaid payback provision if it's third party money. So you don't mix the two types of money. And a lot of kids wind up with a first party special needs trust and a third party special needs trust. Now, a special needs trust, when you boil it down, it's just a discretionary trust. It's entirely up to the trustee to decide how much, when, why, for what reasons we pay out any money to or for on behalf of the ward. That's not to deprive the ward of anything necessarily, but by the ward is not going to be the trustee. Somebody else is going to be the trustee, and it's going to be in their discretion. The ward has no demand rights on the trust. Uh, Therefore, they're not deemed to have access to any of the income and assets in the trust. So even though the trust is set aside for their benefit, they can't, of their own volition, take anything out of the trust. So the government doesn't count any of the assets or income of the trust against them in determining if they're eligible for SSI or Medicaid or any other type of means tested program or service or benefit. Um, Able accounts, those are relatively new, maybe within the last 10 years. And basically, it's just a bank account that can be established. You can go to texasable.com, I believe, and work through it. And it's for small amounts of money to be put aside. So, like my daughter works at the Brookwood community, she gets a small paycheck every month. If that were to build up over $2,000, it would knock her off of SSI. Um, if she were still on it. She's actually switched over to SSDI now. But for any, the ABLE account allows the accumulation of those small amounts of money that a beneficiary award may be accumulating. Now, sometimes people
Another
don't.
thing, just real
Sure.
quick, Bill, I do want to point out that us at Consolidated Planning Group, we can open up an ABLE account for you and
Okay.
go over the rules and regulations. There are, 50 different ABLE accounts across the US. Almost every state has one. You are not required to necessarily use the state ABLE account for the state that you live in. So it's pretty cool. You have a lot of choices, and we can help you sort through those and help you understand how to use the account and sign you up for one.
Cool. That's a good benefit. We don't ever get involved with establishing them because we're not the bank and we don't do the kind of consulting that Consolidated Planning does. But they're a good resource for these types of things. They've got the experience. Sometimes we need to have the ward has money. They're inheriting monies. Money's been given to them for some reason. And the parent doesn't want to hassle with the investments and the reporting and the accounting. You can do something called a 1301 management trust. That's just in lieu of a guardian of the estate. We can turn all the money over to Bank of Texas or Texas Gulf Bank or one of the others that do special needs trusts and have them take care of it. Now, actually, for any significant sum of money where there are investments involved, that's probably a better alternative. Theoretically, if you're managing as a guardian of the estate and you want to sell IBM and buy Xerox, you got to go through court process to get approval for both of those actions. A trustee under a 1301 management trust would simply do it and report it at the end of the year. So they have more latitude than just an individual would have. And then community administration, that's pretty rare. That's for long-lived marriages. If there's a disabled spouse, the healthy spouse can be appointed as the guardian of the person and community administrator, and then they can manage all of the community assets of the marriage. And there's no reporting involved or required. Some of the courts love it. Some of them hate it because there's no accounting, but it is an option that's available in some instances. Um,
If you're interested in having a corporate trustee or a bank, we're having a webinar on that tomorrow. So check our upcoming webinars and you can learn all about how it works to have a corporate trustee.
cool. Um, Again, supports and services, financial power of attorney, the medical power of attorney to make decisions for the person, the HIPAA to be able to talk with the doctors, the FERPA to be able to talk to schools and get information, and then supported decision-making agreements. Now, oftentimes we do this with adults, and we can also do it with kids turning 18. That we have them evaluated by a doctor to fill out the doctor's letter. And we then use that as the predicate to say if the doctor says they've got capacity to execute these documents, then we do them. If the doctor says they lack capacity, then we've got the what we need to go to court and get the guardianship established. But either way, you've got documented evidence from a doctor that you're making the right decision and moving in the right direction. Uh, Somebody on one of the questions that was sent in ahead of time asked, what is a supported decision-making agreement? What's the difference between that and a financial power of attorney? A financial
Yeah,
power,
there's a question in the chat box too. I think people want to know the difference between power of attorney, supported decision making, and guardianship.
okay, sure. So a financial power of attorney is a principal, me, appointing an agent, Michelle, to be able to act on my behalf. And then Michelle can go and trade my stocks, sell my car, do whatever I need, whatever I can do, she can do. Because we usually do the general broad powers of attorney. You can make them more limited, but usually we're trying to give Michelle the authority to do anything that may come up that I might need to have handled. And I'm enabling her to do that on my behalf. Now, it doesn't take any authority away from me. So I can still be stupid with my money, but it
Go
enables,
right ahead.
yeah. Um, so it doesn't take any authority away from the principal. It simply enables somebody else to act on their behalf. A supported decision-making agreement is just what it sounds like. It's basically a financial HIPAA that it allows. So if I appoint Michelle as my agent under a supported decision-making agreement, it gives her the authority to go to third parties, my 401k provider, my bank, and gather information to bring back and help me understand the decision and work me through the process of making that decision. I still get to make the decisions, but she's going to help me gather the relevant facts and sort through it and organize it and present it to me so that she can help me through that process. Now, on both of those, the principal, in this case me, still needs to have enough capacity to authorize that. I still need contractual capacity. And so not all of our 18-year-olds or adults of older age are going to be able to do that. That's where the doctor's letter comes in, where they will tell us whether the principal has that authority and can rely on that as an alternative to avoid going to a guardianship. If I lack the capacity to enable a financial power of attorney, if I lack contractual capacity and I can't sign either one of those, guardianship is the default. It's the big gorilla waiting in the wings that if nothing else works, then you can go for guardianship of the estate. But we always want to try to do these other things first and see whether they're possible. Um, so you want to anything you want to add to that, Michelle?
No, I mean, I think the one thing that people have to remember is, though, about the supported decision making agreement is that it's more of a gentleman's agreement, right? I mean, it doesn't really hold up in court to protect. Correct me if I'm wrong, because you're the legal expert, not me. But is that right? That the supported decision making isn't really.
Well, it's not authority to do anything other than gather
Mhm.
information to help the principal. And
Right.
um, and the problem we run into with them is that third parties, banks, title companies, car dealerships, what they don't understand these things yet. They're still too new.
Right.
They've been around for a few years now, but there's the world hasn't caught up to it yet. Since we're in the business and focused in this area, we know all about them. But a lot of other attorneys that don't practice in this area and a lot of third-party vendors have never heard of them. So there's there's some friction in the gears. Not that you shouldn't try
Mhm.
it, not that you shouldn't use that as your first alternative if it's available, but you may be forced into a guardianship just out of necessity of dealing with third parties who don't get it, which is a
Right.
sad result, but it happens. Okay, let's see here. Next slide.
There you go.
There we go. So the process for a guardianship. First, we try to figure out if there are any other supports and services available, and we get a doctor's letter. Sometimes the doctor's letter comes first to help us decide whether there are other supports and services available. But assuming we need to go for a guardianship, then there's the court filing to initiate the process. This goes back to Declaration of Independence. life, liberty, pursuit of happiness. This is actually a judicial intrusion into the proposed ward's life, into your child's life, to say that they no longer have the liberty to make certain decisions in their life because of their lack of capacity, and that someone else is granted the authority to make those decisions for them. So, deprivation of liberties. The courts put a lot of legal trappings and process around this. This isn't something that you can jump into. It takes time to do these guardianships, 2 to 3 months usually at the minimum. So we do the court filing. Three people will come out and visit with the proposed ward and family probably. A constable will come out and serve papers on the proposed ward in uniform to tell them that they've been sued. This is a lawsuit against the ward to take away their rights. Um, and they require a constable in uniform because they want to bring home to the individual the gravity of the situation. Now, the constables that do this, they get it. They're going to be as gentle and unassuming and friendly as possible. If the proposed ward is lying in a hospital bed unconscious, they'll just go in and lay it on the table next to the ward. I mean, they get it. They work with families. They call ahead of time usually. They don't just surprise knock knock. They get it. Also, a court visitor will come out and visit with the family, kick the tires, make sure that they make an initial assessment of whether this guardianship, the proposed guardianship, actually belongs in the courts. Uh, this was quite a few years ago before some of the reforms that were made, but one of the judges in Harris County told me that he washed out about 30% of all the guardianships filed in his court based on the court visitors report because people stumbled into the system not really knowing what they were doing. Nowadays, it's a little easier. We don't have that issue because all of the people who do guardianship are required to go and get an extra certification from the State Bar of Texas to have minimum education requirements. So it's not quite as bad as it used to be. Also, with the emphasis on supports and services first, we've actually seen a decrease in the number of guardianships that are filed. And most of the ones that are there's rarely an issue with the fact that it needs to be a guardianship. Um, then an attorney ad litem is appointed to represent the proposed ward. This is another attorney who's certified in guardianship. Their job is to zealously and vigorously defend the proposed ward against this guardianship. Now, if Bobby is walking around looking pretty normal, they may ask for a second medical opinion. We picked the first doctor. What would an independent doctor say? But it's all going to turn on the medical evidence. Actually, at the end of the day, I don't get a vote. Michelle doesn't get a vote. Nobody gets a vote except the doctor and the court. And the court's just going to go with what the medical evidence says. They're not going to second guess that and say that they don't like the doctor's letter and we should do something else. That that protects the court. It protects everybody. Now, if it's clear that a guardianship is needed, then the attorney ad litem's role becomes more to make sure that no more rights are taken away from the proposed ward than absolutely necessary, and that the right person is being appointed as the guardian. Sometimes a family member, parents usually the first ones, but then maybe it goes to the big sister. And Bobby is just, there's a lot of family history there. And Bobby is just violently reactive to having Big Sis manage his life. Okay, then we may look around to see if there's someone else available. But that's kind of the attorney ad litem's role. Eventually, there's a hearing on the application where we bring all the evidence into the court. The guardianship is usually granted, and then we're into the annual reporting phase. Um, Now, if you are a parent, the only time we have co-guardians, this goes back to a couple of the questions I saw in the only time you have co-guardians is if it's a married couple. Um, Otherwise, it's a single guardian. It can't be mother and son as co-guardians of daughter in that instance. Now, if mom is the designated guardian, she can actually then do a document called Designation of Successor Guardian for Adult Incapacitated Child. where she nominates son to be the guardian. Now, some people do pre-need designations of guardian for minor children or for their adult incapacitated children. Those are basically nominations to the court of who the parent thinks or who the first guardian thinks should be the successor. The court always has the final decision on who will be the guardian. And they will, these days, we've toughened up the requirements. A proposed guardian, any proposed guardian, has to go through fingerprinting, DPS background checks, things like that. They have to do some online training. And occasionally, the person you would think would become the guardian doesn't because of some issue. I remember one case I had where I was an elderly gentleman and I simply refused to let his son become his guardian because the son hated the father's guts. Dad had always been a miser, had always treated the wife, my son's mother, very poorly. And the man just hated his father. And I wasn't going to let him
Mhm.
be his father's guardian. So I just told him it wasn't possible. Um,
Are there often kind of custody battles like you would see when
Yes.
a
Well, if it's a
parent
divorce,
divorces
yeah,
children?
if it's a divorced case, you can refight the divorce in the guardianship of the child, and those get
Mhm.
pretty nasty. If it goes into a guardianship fight, the sky's the limit on how much this can cost. And the guardianship code is kind of odd. It has some things that automatically disqualify somebody, but there's a sort of a catch-all that a disqualification for someone of notoriously bad repute within the community. Well, you can imagine what comes in under that. And so,
Oh, yeah.
yeah, it gets pretty nasty on those guardianship fights. So it's best to avoid those if at all possible. Um, so, moving along, the point of all that process is just to say this is a process. It's not a quick and dirty. Back in the old days, I could get a guardianship granted in an afternoon on an emergency basis. You can't do that any longer.
Mhm.
And so this is not now. If your child is approaching age 18 and you know you're going to have guardianship of the child, you can already get the doctor's letter. We can actually file for the guardianship after the child turns 17 and a half. We can't have the hearing to grant the guardianship until the 18th birthday or thereafter. But you can start the process 6 months in advance if you know you're going to have to go through it. Um, so they're not static, as I mentioned earlier. Uh, a ward can be restored. And so the code specifically says that starting 1 year after the guardianship was granted, the ward can petition for a review to either give increased rights or to do away with the guardianship altogether. Um, and if the person was partially incapacitated, you can also get the guardianship expanded if they deteriorate and lose ability. Um, or if they're getting better, you can give them back some of their rights. So it's not a one and done. It's not static. Um, the other thing I'm going to throw in here, there was a couple of questions about can you transfer a guardianship? So guardianships are supposed to be located in the court in the county where the ward is resident. And so we've actually done transfers from Harris County to Fort Bend County, Harris County to Amarillo, whatever county that is. We've done transfers to another state. We do quite a few transfers into this state. And so the guardianship follows the individual. Um, the other thing is somebody asked a question about guardianship versus conservatorship. In this realm, Texas uses the term guardianship. Other states use the term conservatorship. It means pretty much the same thing. Those are pretty interchangeable. Um, so, and then the court visitor. Oh, okay, this slide is what if you think somebody possibly needs a guardianship, but you don't really want to get involved? Maybe it's your next door neighbor. Maybe it's somebody at the church that you're aware is having issues. It could be any number of circumstances where you see something and it's, see something, say something. I was visiting in London recently, and they had these mottos up everywhere. See something, say something, we'll sort it. So so if you just write a letter and you can contact Michelle or me, and we can actually give you the code section and the requirements of what goes in the letter. Basically, you're going to tell the court everything you know about the situation, and contact information for people who are relevant, and send that to one of the or to the statutory probate court here in Harris County, or whatever court handles guardianships in your county. And the court will take that and they will act on it. And they will appoint a court visitor to go out and interview the relevant parties and write a report to the court. And sometimes that results in the court initiating the guardianship on its own motion and finding an attorney to bring that forward off of their index of certified attorneys. And sometimes it just goes away. But if you're just worried that somebody really needs some help, you can actually trigger the process by turning it over to the court. Okay, next slide.
You got it.
Okay. Um, no, I got it. Okay, well,
No. All right. I got it for you.
up
There we go. The Bill of
there we go.
Rights.
All right, Bill of Rights. Where did it go? I'm bouncing all over the place.
There
There
you
it
go.
is, Bill of Rights. So Texas has a Bill of Rights. You can just Google Texas Guardianship Bill of Rights. It's got about 30 something items on it that basically are trying to preserve the word's dignity through all of this process. Uh, and for example, the guardian the guardian can be out of state. We've had situations where mom's in California and the word is here. But mom has to visit ever so often. And how is
Mhm.
mom staying involved from California and monitoring what the word's needs are? And so, how does that work out that she really understands and stays on top of things so that the word doesn't have unmet needs? And that's what some of these Bill of Rights address is how do we make sure that the process continues to work? And how do we treat the word with as much dignity and respect throughout this whole process as possible? Um, okay. Priority. If nothing has ever been done, as an adult, you can do a pre-need designation of guardian for yourself. And it basically backs up and reinforces the powers of attorney that you execute. We want to use the powers of attorney, but if you've appointed your son as your agent under a power of attorney, and your daughter thinks son isn't doing a good job, she can file for guardianship. Guardianships knock out powers of attorney. So you can do a pre-need designation of guardian and say, this is who I want my guardian to be under these circumstances. Guardian of the person usually follows what she put in her medical power of attorney. Guardian of the estate would follow what she did in her financial power of attorney. So the message to son is, or to daughter is, don't bother with trying to go for a guardianship because it's going to wind up being the same person. So if anything like that has happened, then we go with who's designated. Then the pecking order is spouse, adult child, parent, sibling, or other interested person. The court always has final determination of who we're going to appoint. Um, that's pretty much that. And then I had
Yeah, we're going to
one.
dive into some of these questions. I'm going to leave your slide up so people can write down your name, your phone number, your email address. And then
Sure.
as we go through these questions, I'm going to flip through a few of my slides in the background because I know people are here to see you, not me.
So,
So let's see, what have we got first? Well, first of all, there was a very big, important question asked at the beginning of this. And I said, let's address that in the discussion afterwards. But basically, to boil it down, what do we do about, issues due to insufficient coordination of care and, treatment plans that just aren't working and things that just aren't working? And um, special needs classifications. Like, what can we do about the larger system kind of failing us? What would you do, Bill?
I refer to my friends
I
at
told you.
Consolidated Planning, who are
Yeah, yeah.
yeah,
I mean, I would say reach out to we've got to make noise. All
yeah,
these silly little rules that we have to follow. Like you can only have $2,000 in the bank unless it's in an ABLE account or in a special needs trust. Who can do anything with $2,000? We
right.
need to be contacting our representatives, advocating for our families and for others, and really being loud and pointing out what's not working for us, I think.
I think that's an excellent suggestion. And it's people who are running into issues and having problems. You make the best testimony in the legislature. You are living
Exactly.
it. You have the experience. You know the problems firsthand. Bring that to the attention of the powers that be. And so there is a guardianship legislation that is proposed every legislative session. But the work on that starts as soon as the previous legislative session is over. And so finding out, I mean, the Texas, there's there are attorney groups who try to manage some of this legislation. There are other interested parties. There's the Texas Guardianship Association, which provides a lot of resources and training for anybody who's a guardian. It's a small fee to join every year, but it's certainly worthwhile. And just continuing to Google and now do AI searches and learn as much of this stuff as you possibly can on your own, being aware that the rules in Texas are different than the rules in anywhere else. And so you have to sort through some of the chaff that's online to make sure you're understanding what the situation is in Texas. And just, I mean, I like educated clients who
Mhm.
come to me with questions uh, because it's sharp, iron sharpens iron. And I know a lot about this stuff, but there were a couple of these questions that came in today that I called my partner Lisa and said, "Hey, Lisa, what about this?"
Yeah.
So uh, we all continue to learn, and it's a community endeavor. And there are probably some pretty good chat groups going on
Oh, yeah.
where we share knowledge. I remember one of
Do
the
you
very
want to, do you want to take one of the questions that was sent in earlier or some more that were from today?
today is fine, or either
Okay.
way. If you've got some queued up, go for it.
Yeah, I've got some easy short ones. If you become guardian, are you automatically the person's representative payee? Or is
No,
that only if you're
no.
guardian of the estate?
No, neither one.
No, neither one.
So guardianship is state. Representative payee for any kind of federal government benefits is federal. Federal ignores state. It doesn't matter if you're already appointed as the guardian or the power of attorney. You're still going to go to Social Security and sit in their office and present your information to them so that they can vet you and decide that you're the appropriate person to be the representative payee for that person. One of the good things about that process is that if you are a representative payee receiving income on behalf of the disabled person, you report annually back to Social Security or VA as to how you spent the money. You do not have to account to the state courts on that because that's all federal, and the federal has monitoring and oversight over that. But it's a different system, and it doesn't translate from one to the other.
Perfect. Now, how much does all of this cost getting guardianship? And
Yeah. Well, we do quite a bit of it, and it varies whether we're doing guardian of the person or guardian of the person and estate. I think if we're doing guardianship of the person, it's probably coming in a little less than 2,500. If it's guardian of the person and estate, it's probably more like 5,000 to $6,000. That's all assuming that there's not a fight, and
mhm.
because we don't do the fights. When a fight erupts, we turn it over to the probate litigators. They like to snap, bark, bite, growl. But that's not us. So, but for that happens rarely, and so those are some ballpark numbers for you. But anytime you're looking for a guardianship attorney, call two or three attorneys that do this work, talk to them,
Yes,
ask them
definitely.
questions. Is it a good fit? Are they explaining things in language you understand? Do you have a good rapport with them? And ask them about their fee structure. That's all very legitimate.
So I'm showing a slide right now. You know, you can look at this, click this link. It will take you to our website for our upcoming webinars so that you can pre-register. Like I said, tomorrow, I think the webinar is about something that's going to be helpful to some of the people on here, which is totally gone out of my head right now. However, I can pull it up. It is answering your questions about choosing the right trustee. Oh, yeah. We talked about that, trustees for the special needs trust. So, Bill, I know that this is a very, it depends kind of question, but people want to know, how do I know? Do I need guardianship or will a power of attorney be enough?
Um, yeah, and you probably won't know unless, or not definitively, until you get that doctor's letter. Now, if you've got some doctors that the proposed ward is routinely seeing, and just share that letter with them and ask them how they would fill it out. And just point blank ask them, does Johnny have enough capacity to do a power of attorney? Based on
Mhm.
this definition of what capacity means or incapacity means. And because that's really what it boils down to. That's what the courts would follow, and that's our best recommendation is. And so even when we have an adult, and we had one recently, Nancy, and Nancy was starting to lose it. You could tell that. And then we had to be very careful how we asked our questions because she would get lost pretty easily. So we had some real questions of whether Nancy had adequate capacity to even do a will. Our proposal to Nancy was, let's have Dr. Poa come to the office here and examine you at 10 o'clock. And if at 11 o'clock he says you're good to go for signing a will, we sign it. And if he doesn't, then we do something else. But that's kind of the proof of the pudding is what would a doctor say?
Okay, perfect, perfect. Um, if I'm guardian of my adult son in the future, can I get paid by class by the waiver programs for respite hours? Do you know if that's
I'm not a class expert, but I believe you can. Um, I think so, but I would have to
okay?
double check that against the rules.
Okay, okay. Now, do you have a standard form for power of attorneys, or is it like people can just download that, or how does that
Uh,
work?
there is a standard Texas form. We don't put our form online because there are some things that are unique to it.
Mhm.
The Texas,
Proprietary
well,
information.
not proprietary so much as could be confusing. So, for example, one of the standard Texas statutory durable power of attorney form has incorporation by reference. And so there are like 18 bullet points, real estate transactions, banking transactions that incorporate pages and pages and pages of statutory text into the power of attorney. It makes them standardized that every power of attorney on this system since 1993 means what every other power of attorney means. So it makes it easier for third parties to accept them and use them. However, having said all of that, we've got about 60 different paragraphs that we can add that address very specific situations. And we've got some standard recommendations, but then depending on what the circumstances of the engagement, we may come up with three or four other paragraphs that we think would be really helpful in this engagement that we would then add in. Another decision to make on the power of attorney is whether it's effective immediately, not affected by subsequent incapacity or disability, or whether it only springs into effect in the future if, in fact, somebody is disabled, if the principal is disabled. A lot of our clients initially think they want that second choice because they don't want anybody messing around with their stuff before it's absolutely necessary. But if that's the option that they pick, it's not a complete document on its face. their agent would take it to the bank, and the bank would say, well, you only have authority if Marge is incapacitated. How do we know what Marge's condition is? Say you've got to go get doctor's letters or other things to try to prove that Marge lacks capacity, trying to prove to the bank that the condition exists that allows the power of attorney to be effective. We always, when we're talking clients through it, try to steer them toward picking option A, which is effective immediately. Our theory is if you can't trust John to not do anything stupid with your stuff when you're alert and can watch him, this is who you should pick for when you're in the hospital. So we tend to steer toward that. But if we just made a form available, a lot of people wouldn't get that right off. That's not obvious or intuitive to a lot of people. So we try to work through these things with people on a customized basis is our approach.
Perfect. I think we have time for one or maybe two more.
Go ahead.
So if a child, like let's say you have someone under guardianship and one parent is the guardian,
Mhm.
and then that child, but over the adult child,
Right.
let's say it that way, they decide that they want to go to the other parent. Are they allowed to do that, or does the
Oh,
judge,
yes.
really
Yes.
look at whether or
Yes.
not they're being coerced
No,
or
no, we've had we've had situations where we have changed guardians for somebody three or four times. Um,
okay.
we had one sad case where a young lady, she had a lot of issues, and her mother became her guardian. Later, her husband became her guardian, but then he developed cancer, and so he shifted it
Oh,
back to the mother. Later, the mother became guardian, and the mother developed cancer, so we shifted it to somebody else.
oh
Uh,
my goodness.
yeah, it just goes. So it's something that is evolving and continuing, and you can review that at any time. Is this
But
still the right case?
each time you change, does the judge,
Yeah, each time you change, you have to do a new
reconfirms
application.
that new person?
Yes, yes. It's only nobody is a guardian unless the court appoints them as guardian. Um,
Right.
so that has to always go through the courts. But you
Okay.
can change guardians from time to time. I had another case where there was a very disabled sister. There were three sisters. One of them was very disabled, and we would trade guardianship between the two sisters back and forth every year or so. Because one sister
Okay.
would do it for a while and she'd burn out and we'd give it back to the other sister. So
Yeah, that makes sense.
yeah, so it's a little bit of a hassle, but yeah, it works out. Somebody else asked if
Perfect.
they're the guardian of the person of their child, but their son lives nearby and the son wants to go to medical appointments because it's more convenient for him. How do we do that? I was discussing it with one of my partners, and we decided that she could probably, as guardian of the person for Angela, do a HIPAA authorization that enables Johnny to go to the doctors and talk to the doctors with Angela. So that would be one solution. The dirty little secret is doctors just talk to whoever's standing there. I mean, we do all this paperwork and then the doctors just talk to whoever happens to be standing in the room. It's
Hmm.
so yeah. Any other
Yeah.
questions? Yeah.
Okay, last one that we have time for because it's 12:59. But if the disabled adult gets in trouble with the law, does having guardianship help?
Possibly. We've got some evidence on record already that they may not have their full mental faculties. Therefore, they may not have the appropriate mental state to be responsible for what they did. So that,
Yeah, I see this question is asking, like, what if they get a ticket or something like that? I mean, that could go back on the guardian, though, right? Like, how did
no, actually
this
not.
person have access to the keys?
Yeah, that's I've not seen that happen. Just because you're guardian for someone doesn't mean you're automatically liable for any debts or obligations or anything that they incur or tickets that things like that. Obviously, if you're allowing them to do dangerous things, the police may refer you to APS and say maybe this person shouldn't be the guardian, but it's not going to
Yeah.
come on you directly.
Okay. Fantastic. Thank you so much. And I want you to know we've gotten so many notes in the chat box thanking you for the information you have shared here with us today, Bill. I really appreciate it.
Sure.
And thank you to everybody who has hung out with us today. I'm glad that you've learned some stuff. Feel free to contact me or Bill for consultations. We
Or if
still do
you,
have
yeah,
part.
I was going to say, and actually, if you just have more questions, just email me, tell me you were part of this conference. I'm happy to trade emails with you and answer questions. No obligation.
Perfect. Thank you so much. Everybody have a fantastic week and we'll see you again soon. Bye bye.
Bye bye.